Hello, I'm George McCraney, DUI and criminal defense attorney with offices in Douglas and Valdosta, Georgia. Today what I wanted to talk to you about was if you have been charged with a felony, I want you to understand and learn about what to expect in the Georgia criminal court system. Now, I'm a former state prosecutor. I prosecuted all types of criminal cases, from murder to speeding, from drug trafficking to misdemeanor possession of marijuana. I know their criminal cases. Now, I've been a criminal defense attorney for over 20 years. I've successfully defended clients in everything from murder cases to DUI, from kidnapping to possession of drugs. Now, at my firm, the attorneys are trained and experienced, and they are dedicated to getting each and every client in their case. Now, if you've been charged with a felony in Georgia, it's extremely serious. Now, a felony is a case that carries more than 12 months in jail. All right, that's a felony. What you're looking at out of jail, all right, if you've been arrested. Now, sometimes the charge is bondable by a magistrate court judge, and that judge will set the bond. All right. Now, sometimes it requires a defense attorney to negotiate with the DA, and that's the government's prosecutor in felony cases, to negotiate with them to get an agreed upon bond. It's called a consent bond. Now, sometimes the charges are so serious that it requires a superior court judge to decide whether or not to set a bond, and that can be either before or after a formal bond hearing. Okay? Now, if you've been charged with a felony, it's extremely serious, because you need to remember, if you're convicted of any criminal charge in the state of Georgia, that conviction will never come off of your criminal history. Okay? Georgia has some of the toughest laws when it comes to criminal records and criminal histories, and a lot of people think that, well, I got convicted, but that was years ago, it's probably off my record. It doesn't work like a speeding ticket. Georgia convictions stay on your criminal history for the rest of your life. Extremely serious. Now, if you got a question about this, feel free to give us a call. You can reach us at 833-927-6227. Or you can go online to McCraneyLawFirm.com, and you can find a lot of videos. I've got a bunch of videos on there talking about different aspects of a criminal case. And you can also request a free copy of my latest book, which is The Truth About Your Georgia Criminal Case. And it goes through and details the full process for you. But now remember, as good as that book is, it gives you a lot of great information. It doesn't take the place of a trained criminal defense attorney. You really need to get an attorney if you're facing especially felony charges here in Georgia. Now, after you get a bond and after you get released from jail, the case will go in front of a grand jury. And the grand jury decides whether or not to true bill the case or indict the person or not. Okay? Now, defendants get to go to grand jury. Only the government gets to present their witnesses at the grand jury. The only exceptions to that is if you're a law enforcement officer, you can go, and if you're an elected official, you can go. All right, but regular people don't get to go to grand jury. Only the state puts on their evidence there. All right, they get to have their own witnesses. They get to tell everything they want to tell, and there's no rebuttal from the defendant, none at all. All right. Now, in my area of the state, most counties' grand juries only meet twice a year. Okay, so the way a grand jury works is they can add charges. So if you're charged with a crime, they could add another crime, or 2 or 3 or 4 more crimes. It just depends. They can also take off charges. All right. So the grand jury decides whether or not they're going to indict the case. All right. If they indict the case, then that case will then move before an arraignment on the indictment. That's where you plead guilty or not guilty to the charge. All right. Now, after the arraignment on the indictment, the case will then go for a calendar call, motions where the attorneys come in and argue motions about what evidence is able to come in, what evidence is not able to come in, and then it would eventually be set up for trial. Now, these felony cases are extremely serious. Don't try to fight these cases by yourself. All right. If you're convicted, it will never come off of your record, and you're going to have to explain 20 years down the road why you were convicted of this charge. And you certainly don't want to say, well, I defended myself or I represented myself, and I just didn't understand what was going on and I got convicted. You want to get, this is my completely free advice, get the best attorney that's available to you to defend you in these type cases, because that's how serious these cases are. Okay? Now, anytime that you're dealing with a felony charge, remember, that's a case that carries more than 12 months in jail, so it's a serious charge. Please take this stuff seriously. Don't think it's just going to go away. It's not. It's going to come up and it will bite you. Okay, really it will. If you have a question, feel free to call us. You can reach us at 833-927-6227 or online at McCraney.Lawfirm.com. And like I say, if you'd like, request a free copy of my book, The Truth About Your Georgia Criminal Case. It will give you all that information about it. We'll send it to you absolutely free. And we donate all the proceeds from the sale of those books. If you'd like to buy one, feel free to go on Amazon and buy one on Amazon, but we'll send it to you absolutely free. And we donate all the proceeds from those books to charity here in Georgia. Okay? If you got a question, feel free to give us a call, and we'll be glad to help you answer any of the questions that you have. Thank you.